Hey, my name is Attorney Walter Rudolph Hnot III. We're going to be going over another question that's from Volume 38, Number 8, August 2016, NOSCR, little pamphlet thing. It's page 9. The question was, sometimes cases are expedited without the claimant or representative requesting that they be expedited, and then the case is denied. Example of Wounded Warrior, denied because ALJ found the impairment would not last 12 months. Is there a way to reject a critical case flag if it is placed on a file? The SSA's response is that basically, and they gave a hearing level response and appeals council response, that they follow their policy. Policy states that they can only remove a flagging if the case was erroneously identified as a critical case or the condition that formed the basis of the critical designation is no longer present. Which answers that question, because, if they're looking to say, well, you had this problem with a warrior situation and they're healed now and it's no longer present, then they can remove it. They state HALX I-2-1-40, which is the classic. There's a total of 6 inside that law. The ones I tend to use the most are, subsection 5 and subsection 6. Subsection 5, rather, is dire need situation, because I work with a lot of homeless. Subsection 6 is basically SUIC or HOMI based listing categorical reference, which means suicidal or homicidal claimant. Provides procedures for determining whether a case is critical. There's another law here that they didn't include, which I think they should have included. It's basically another HALX, but it's an actual form, and the SSA completes it basically as to whether or not the claimant is dire need. And other certain forms as well, they go into detail about whether or not an individual has an expedited claim status, should be given an allowance. But they didn't include that there. That's okay, though, because that's the beginning of law. Inside this law, it'll state that for you. So if you go read it, you'll be able to see the other thing. Another one, appeals council, the response was, we follow the policy. Policies are put in place for claimants that have been waiting way too long. Reps should continue to timely submit all relevant evidence. Now, I know that with this question, it's basically a question to see how a flagging can be removed. But what I really want to go into with this, because that's kind of answered with that question, what I really want to go into this is expedited claim status. When somebody gets an expedited claim status, it means it's flagged. It gets a little red flag on the website, or it gets a red flag on the folder. It means it's sped up. The classic one that I see a lot of is SUIC-based rating under I-2-1-40 subsection, I think it's A, subsection 6, which basically states that, hey, this person in particular, is harmful to themselves. Remember, suicide is harm to oneself, homicide is harm to somebody else. Okay. And what you need to know is that, yeah, okay, cool, this person can get a hearing really, really fast. That's true. That's very accurate. But sometimes you need to get more evidence for a claimant. And what do I mean by that? A lot of homeless claimants, they'll have a difficult time driving to, or they'll have it in their mind that they don't want to rack up the bill for medical documentation to go to the hospital and get treated. So they just won't go, and you won't have the evidence required to go ahead and prove that they are the disabled person on which they claim they are. The SSA's response to that is, well, how do we know that this thing is really severe? A. B, how do we know it's going to last for 12 months? They have one of the rules as part of the 12.04 base listings that they're really shooting for and looking for essentially 2 weeks out of every 4 months that a person with a mental depressive disorder, be in a mental facility 2 weeks of every 4 months. I think this is a good law, because if somebody's really that bad, they should be in the medical facility. If they're really that severe, they should be. The counter argument to that, of course, is, well, what happens when the claimant's in the middle of nowhere and, they can't get to a mental facility? Well, then the rule is completely useless and is terrible. So a lot of the problems we run into include, okay, well, the person living in the city is going to be more capable for a 12.04 base listing to meet that standard than an individual who's living on a farm in the middle of Wisconsin. Okay. So I'm answering these questions, I'm doing these questions because I want to give you some of the logic and background that I think about when I'm reading these, so that you'll have a better understanding as to what other little things lurk out in the darkness and the shadows that are required to really make this thing work. And I know with politics, everybody usually shoots from the hip and I want this, and it should have been like this, and blah, blah, blah. And that's good. That's good. We need to have that. because that's how we line up the pros and the cons, and that's how we line up the blue side and the red side, and that's how we figure out where people are at, you know. If everybody knew what a Republican was, well, it would make voting easier. If everybody knew what a Democrat was, or, you know, it would make voting easier. There's not a single person on earth that can define what a Democrat is or a Republican is at this point, because everything's so convoluted. You know, you could go to Wikipedia and try and get an answer, but frankly, it wouldn't be accurate. There's no way to define it. It used to be a lot easier back in the day, though, so I'm told. But anyways, that's that whole question as to expediting a claim. I have another video out there about what the different expedited claim forms are. So if you want to know more about that, you can give me a call. In my opinion, don't be, and I call it foolhardy, or I call it a lot of things, but the polite version is, you know, don't be super excited to, you know, escalate and expedite your claim if you don't have tons of evidence. Don't be. A lot of you sit back and you think, I have one doctor that stated that I was disabled and that I can't work and blah, 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 and therefore I am ready. I should be found disabled right now. I'm filing today and tomorrow it should be done. Don't be a fool. Don't be a fool. Don't be one of those lovely individuals who, you know, they're just, don't be one of those. Call an attorney, ask how it actually works. We'll walk you through it. All right. We don't make specific videos about your particular issues. We do make general tutorial videos. So if you would like to have a general tutorial video made, that's fine. But if you want to get specific information related to your claim and a response from me, go ahead and shoot me an email or give me a call. Next thing is this. If you want the most up-to-date information, or you do have a unique question for your unique claim, that's fine. Shoot me an email or give me a call. Finally, we have made more Social Security disability videos than any other human being on earth. So if this is your first one or you've never seen me, then that's surprising. But at this point, if you do have something that you really, really want to know about, make sure you put in your email or your phone call to me. It's urgent. You really want to know how something works. And then give me kind of a lead line on, you know, general stuff as to, you know, what you'd like to go to with a specific aspect. And then I'll make a general tutorial video about it and potentially go into examples that may include your particular issue. All right. My name is Attorney Walter Rudolph Hnot III with Disability Resolution PA, in Orlando, Orange County-based Social Security Disability Law Firm. You have an absolutely wonderful day, and I will catch up with you later, all right? Thanks so much. Bye-bye.